The state of Michigan versus Kendra Scott. This is here for sentencing today. She is over in the jail. We need to have her brought over. This is going to be case number 24-3546F8. All right, Ms. Scott has been escorted here in the courtroom. Also before the court this morning is Ms. Laurel. Let's start off with 15.
15 of 17, the arrest date is 3/20 of 25.
Okay. Any other, is it still pending?
No,
Okay.
Final charges were retail fraud third, the original offense.
Mm-hmm.
She entered a plea on April 8th and was ordered to pay $240 in fines and costs.
All right. No other probation?
There's no other probation on that case.
All right, let's take a look there at 16 and 17.
And 16 of 17, the arrest date is also March 20th of 25.
Okay.
And those charges were dismissed on April 8th as part of the plea agreement in the above case.
All right.
Your Honor, we do have a couple objections to offense variable.
Let's get to them.
All right. On count 1 and 5, offense variable 15 is scored at 5 points for an indication of trafficking.
1 and 5. Count 1 is the possession of meth, and I just want to make sure I'm talking about the charges. We have a possession of meth. All right. Thank you.
As the court may recall, the jury trial, the court granted a directed verdict as to the possession with intent on count 1. So just a possession went to the jury. As to count 5, conspiracy to possess with intent to deliver went to the jury. She was acquitted on that, found guilty of a possession. I understand that
the judge begins with formalities, setting a calm tone. But this calm won't last. This moment determines whether Kendra faces years in prison or walks free. Every word matters because it signals what's coming. Do you think the judge already has a decision in mind, or will arguments change everything? Drop your prediction in the comments.
Had this been a plea, this may be a different outcome, but she has specifically been acquitted by this court and then by the jury as to any indication of trafficking. So I would ask that that be scored at 0. As to counts 1 and 5, for the court's information, that objection and change does not change the guideline range on those two.
Thank you very much. Mr. Denham, your response as to that objection?
Your Honor, my understanding is the case law does not preclude, even acknowledging the fact that she was not convicted on that count. It's my understanding the case law does not preclude the scoring of that variable. Your Honor, the Honor is well aware of the facts and circumstance. Obviously, this went to trial. There was narcotics and narcotic paraphernalia throughout the car, as well as, I think importantly, the jail calls in which the defendant stated what her intentions as far as what she was doing, the quantity of drugs that she was going from Saginaw to get. In all those factors in consideration, I believe that it was the scoring was appropriate in that case.
All right, thank you. This court will grant that objection. It is, while yes, she doesn't have to be found guilty of that offense, and yes, the court may find by a preponderance of the evidence that there was evidence of trafficking despite the conviction for possession. I dismissed the possession with intent to deliver, which definitely says that at the time, and finding, I'm going to say, no, there wasn't any evidence of trafficking. There was evidence of wanting to go traffic more drugs, yes. But they never got down there because they got stopped by police. The court will grant that objection, strike off that variable 15 for counts 1 and 5, score that at 0. That changed the total offense variable score from 15 down to 10 for each of those two offenses. However, as stated by, hold on.
Defense makes their first big move, challenging the sentencing guidelines. These guidelines aren't just numbers. They control how much time Kendra could serve. Lower scores mean shorter sentences. Will the judge accept this objection or shut it down? If you were in the judge's chair, would you allow this argument or stick to the original guidelines?
Yeah, it's the same score for that count as well. All right. I said that count, I meant count 5. All right, thank you very much. And I'm just going to confirm should be 0 to 9 is yep, and then 10 on. Good enough. All right, Miss Anderson.
Thank you. Your Honor, as to count 2, we are objecting to OV9 and OV13. Again, the court presided over the jury trial and observed the videos relating to the resisting, obstructing. Your Honor, there was a brief moment in time where Miss Scott exited the vehicle and ran. She immediately got back in the vehicle without anybody being placed in danger, without any danger to anyone's property. And then she sat in the vehicle with the doors locked. She did not do anything to endanger anyone or to cause any damage to anyone else's property. So we would ask that OV9 be set at 0. Your Honor, I don't know if the court wants me to go right into 13 or...
Hold on. Nope, let's take a look at 9.
Thank you.
I don't recall, were there any firearms located in the vehicle?
I believe there was ammunition in the back. There was testimony that one of the officers heard the word gun. He had testified very clearly. He did not know if she was referencing a gun in the vehicle or something along the lines of they've got the guns. So we don't know what she was referencing from that, but there was reference to that word.
All right, thank you. Only on offense, never mind first.
Sure. Yeah, sure. So the court, again, is well familiar with the facts. I guess I dispute that it was a short period of time. This went on for several minutes. The court saw the video. The fleeing occurred first. Then the testimony from Deputy Frolenko, or Detective Frolenko, was that he heard the word gun from the defendant. He also testified, and there was testimony by others, that she locked the doors. And in the video, you can clearly show that because of the...
Notice the body language defense leans forward, voice firm. That confidence, it's strategic. They're trying to influence the judge psychologically. Courtrooms are as much about persuasion as the law, but confidence without substance can backfire. What do you think? Strong argument or just theatrics? Have you ever seen confidence win over weak facts before? Comment your thoughts.
Stressful nature of the encounter. Obviously, guns were drawn. Ultimately, there had to be an axe used to get the people to exit. So clearly, there were multiple, from the people's perspective, there were multiple people put in danger based upon the actions of the defendant. We do believe it is properly scored here.
Somebody's saying or thinking, that's important. The word was an officer thought they heard the word gun. There wasn't any gun found, and just suspecting they heard the word gun was not enough. And I recall the video. We watched it several times. Well, yes, it was an intense situation, and yes, the defendant looked like a cartoon character running around the car and jumping back in and clearly resisting. Don't know how she would have placed anybody in danger, because a law enforcement officer, when conducting a traffic stop, does not have the right to use force or deadly force. They have the right to use some force within reason. And because she did not present any deadly force, we knew no one was going to be shot, and she didn't do anything to put anybody into physical harm. Yes, it was intense, but an officer does not have the right to go into physical violence, but they can use force. And they did use force, but against the car, which was the right thing to do, if I recall. They used was it a hammer or something to break the window? Don't remember.
I'm believing it may have been the end of like an axe, like the backside.
Prosecutor fires back, emphasizing severity. Their tone is sharp because they want the judge to feel pressure. Remember, prosecutors don't just argue facts, they frame narratives. Here, it's about making Kendra seem like a threat. Does this tactic feel fair or manipulative? If you were the jury, how would you read this approach? Persuasive or overkill?
Or something, yeah, something. That was fine. They had the right to break the window. They had the right to take the people into custody. They had the right to take the defendant in custody. They had the right to do their job and search the car, secure the scene, protect themselves. They had all that. But at the same time, everyone else who was in the car, if I remember, the window was broken on the passenger side.
I believe the rear
Was-
passenger
yeah.
side.
So that was done by the person in the back passenger seat. Yes, sir.
But, Your Honor, in addition to the law enforcement, there are other people in the vehicle.
Right.
She was found guilty of fleeing. The court is aware of the video, the facts. She ultimately came to a stop because essentially there was nowhere else to go. I mean, she went in.
Right.
So, that fact put the other people, the other passengers in the vehicle in danger,
But
even prior to the stop.
yeah, but that's a different charge. That's called flee and elude. When she resisted, that's why we have two different offenses. The R&O, this count, occurs at the stop or after the vehicle has been stopped and she resists. She clearly resisted from the evidence, from what I call. The question is did she put anybody into risk of physical injury? Let me just give an example. If a defendant gets pulled over by law enforcement and they crack the window and they don't respond and give an ID, don't give insurance, don't get registration, or the officer, and they don't get out of the car, the officer has the right to use some force to get the person into custody, even potentially, this is an arguable situation, breaking the window, like in this instance. But they didn't break the window on her side. She didn't put them, and everybody else, by the way.
Now the judge is asking pointed questions, a sign they're testing both sides. Judges rarely show emotion, so questions are clues. These questions hint the judge isn't fully convinced yet. Who's winning so far? The defense with technical. Objections or prosecution with emotional appeal? If you had to bet right now, what's your guess on the outcome?
Could have been charged with assault and resist, obstruct a police officer. Because the law also says that the officers have the right to make the passengers get out of the vehicle and stand off to the side. And the officers had the right to do a pat down. She got out, ran around, got back in, and refused to unlock the door. That doesn't mean that the officers had the right to put people into danger of physical injury or death. They have a right to break the window, force the door open. They have the right to surround the car and go get somebody with the jaws of life to separate the door and force them out. But that's not what happened. So the court will grant the objection to OB9 on count 2, make that 0. That thus far, I know you have another objection, reduces the total OB from 30 down to 20. Now we're looking at your objection as 13.
Thank you, Your Honor. OB 13, as the court is aware, is scored for felonious acts within a 5-year period. In this case, the agent has scored 10 points on OB 13 because of a conviction for a rental property failure to return, and then for dismissed conduct, an aggravated stalking charge from 2004 that was dismissed, as well as a 2004 unlawful driving away of a motor vehicle. Both of those are dismissed conduct. Your Honor, I acknowledge that unconvicted conduct can be scored, but it may only be scored when there is a showing by a preponderance of the evidence that the felony actually occurred. We have nothing in the pre-sentence report to show that. I've not seen police reports in either of these.
I got it. Mr. Denham, argument and response. By the way, what Ms. Anderson has said is absolutely correct. The court can find when there is no conviction, evidence based upon a preponderance of the evidence, but I don't have any evidence presented. Ms. Anderson makes the right argument so far.
Kendra finally speaks, her voice steady, but you can hear tension. Defendants rarely speak unless advised, so this moment matters. What's her goal? Sympathy. But sympathy alone doesn't always sway judges. Do you think showing emotion helps or hurts in a courtroom like this? Share if you believe heartfelt words can outweigh hard legal facts.
the argument has occurred. First of all, to indicate what both defense counsel and the court has acknowledged. Also, I would indicate that prior to the objections and the conversation that we're having now, we put on the record as far as an update of what occurred on that case. One of the cases was dismissed as part of a plea agreement. It wasn't as it was dismissed. Simply, people in that case didn't dismiss it as part of a plea agreement. And because conviction isn't required, we still do believe that it was properly scored.
Where is the proof that the other offense that was dismissed actually, I need to have proof. Do you have a police report? The fact that it was dismissed for whatever reason, for all we know, the prosecutor in the other case dismissed it, neither one. Yes, we think you're guilty, but we're going to dismiss it as part of the deal. Or the prosecutor said, you know what, this is probably my weakest case. I don't have enough evidence, therefore I dismissed it as part of the deal. The mere fact the prosecutor in the other case dismissed it has no value to the court in establishing a preponderance of the evidence.
The description of the offense narrative here goes into the fact of why the officers in our case were on the scene. It also indicated that the owner had reported that the defendant had stolen the vehicle. That's in the narrative here.
So the stolen vehicle, that's one of the ones that was dismissed?
Your Honor, I don't know.
Defense shifts gears to mitigation, explaining Kendra's background and remorse. Classic move. They're painting her as more than the crime. Judges consider character in sentencing, but not at the cost of justice. Should personal history reduce punishment? Or should the law stay cold and impartial? Drop your take, compassion or consistency. Which side feels right to you?
I'm not financially support for the UDAA charge. I don't know if it's the same vehicle, but
Okay, hold on. That's in the description narrative, so that would be in CFJ 284A. This court hereby finds by a preponderance of the evidence that on CFJ 284A, page 4, there is adequate information in the description of the alleged UDAA, which was the vehicle was taken from Grand Traverse County area, and the fact is that the owner was able to track the vehicle and had a tracker on it, and that's what caused the law enforcement officers to pull over the vehicle because they were able to track it. Therefore, there's a preponderance of the evidence there. That means that there are 3 or more. Therefore, the court denies the objection as to offense variable 19, and that would count 1, right? Thank you. Any other objections to the guideline?
Your Honor, as to, again, that does not change the guideline.
No, so we are at 20 points.
As to count 4, the fleeing and eluding charge, Your Honor, we would again challenge OB 19. Again, the court heard testimony and saw videos. Although there was not an immediate stop, there was no high-speed driving. There was no erratic driving. Ms. Scott is not even alleged to have gone 5 or 10 miles over the speed limit. An assumption that maybe she would have driven erratically after she stopped is not what we're here for. We're not here for assumptions. I don't believe that they've shown anything to, again, indicate that any person, let alone 2 to 9, were put in danger. So I would ask that OB9 be scored at 0.
All right, so OB9 underneath that offense is scored at 10 points. 10 points for that is scored wherever the offender interfered with or attempted.
Prosecutor isn't letting up. They highlight impact on victims, a powerful pivot. This forces the judge to weigh fairness against leniency. Victim impact often tips the scales, especially in high-profile cases. Should victims' pain carry that much weight in sentencing decisions, or should punishment be purely based on law? Comment what you believe is fair.
To interfere with the administration of justice or directly, indirectly violate a PPO. So we know that last portion doesn't apply. The question is whether or not her failure to stop the vehicle. Mr. Denhoughton, if I remember correctly, law enforcement flipped on their lights in the pursuit out there on the road. Is that right?
Yeah, that is correct. So she attempted to evade the stop. That's why she went into the mobile home park. She was originally on M66.
Clearly, she had no idea where she was going because she ended up having to pull in and pulled into a dead end.
Yes.
and then got out and ran.
And multiple over the PA system, multiple attempts to get her out of it. So yeah, we believe it is properly spoken.
Now, with that last comment where I say she ran after she hit the dead end, that's the R&O. That is not the flee and elude portion. So the court denies the challenge for offense variable 19 as to count 4 out of 5 because the whole definition of the offenses, she was failing to comply with the orders of a law enforcement officer conducting his or her job by turning on the lights and failing to stop, and then seeking to avoid by turning into an area that obviously we find out she doesn't know where she's at.
And Your Honor, I was not objecting to 19. I was objecting to 9, which is
I'm sorry. I thought you said 19.
danger. I'm not objecting to 19.
I'm gonna pretend and say no. You said 19.
I may have, and if I did, that's my mistake.
All right, copy that.
It's
So
the danger of life.
Stop. I got sorry, ma'am. I said the word stop. I wasn't trying to chastise you. I was trying to say stop while you're ahead. Offense variable 19 is 0. That is now at 10 points, and that does not change the guidelines. Correct?
Yes, thank you.
All right, thank you. Anything else as to the scoring?
No, thank you, Your Honor.
Allocution.
Thank you, Your Honor.
We're seeing tension rise. Notice the judge's deep sigh before ruling on the objection. That's a tell. Judges rarely show stress unless arguments are strong. This means the defense scored some points. But is it enough to change the sentence? If you were on this bench, how would you handle conflicting arguments like these? Let's debate.
The court presided over this trial. It was not very long ago. I trust that the court's recollection of this matter is fresh. So I would ask the court to rely on its own recollection. Ms. Scott prior to this, had 1 felony offense for failing to return rental property. She is, Your Honor, prior to that, not a serial offender. She has, as I indicated, 1 prior felony. She does not have, we're not looking at somebody with 8 or 9 felonies previous to this. Is this a go big or go home kind of case? It is. She accumulated 5 felonies in this one instance. But Your Honor, as the court may recall, through the testimony, there was no egregious facts in these cases. There's nothing to indicate that going above the guideline range would be appropriate. I do believe the guideline range is appropriately scored. I think the recommendation is appropriate, but because this is the first prison sentence, I would ask that the court consider an 18-month sentence with all counts running concurrent. Ms. Scott, the PSI indicates that she was not at the time of writing eligible for boot camp, but because all of the other charges have been taken care of, she now is. I would ask the court to allow her to participate in boot camp. And Your Honor, again, there is discretionary consecutive sentencing on 2 of these counts. There is no standard of egregious conduct. I understand that, but I don't think there's anything here that warrants a harsher sentence or consecutive sentencing based on Ms. Scott's conduct. She had a very, very bad day. She made a series of significant mistakes, and she is being held accountable with a guideline range of 10 to 28 months. And I would ask the court, again, to consider 18 months, but to not exceed the guideline and to sentence her concurrently. Lastly, Your Honor, Ms. Scott will be given the opportunity to speak. Because this was a jury trial, I have advised her to not speak and to exercise her right to appellate review. So she is not speaking on my advice, not because she doesn't have anything to say.
Judgment moment approaches. The courtroom is silent, a sign of gravity. Every second feels heavier now. Think about it. Months of preparation, arguments, and evidence boil down to this. Does justice mean punishment or rehabilitation? Which one fits better in this case? I want to hear your thoughts before the hammer falls. Comment what you'd decide.
I got that, and I don't hold that against her. I understand and respect the legal advice of counsel. The consecutive sentencing is based upon the fact that she was on bond for a felony.
Your Honor,
she was on probation.
Counts 2 and 3 are
Oh, wait.
discretionary in and of themselves.
Yeah. hold on. Count 2 is the assault, resist, obstruct. And count was 1? 3?
Count 3 is the tampering.
Oh, the tampering.
That has the discretionary consecutive element to
Yeah.
sentencing as well.
All right, thank you very much. Mr. Denham, elocution.
Thank you. First, the people would respectfully request that the defendant be sentenced as habitual second offender, as requested previously. Court is well aware of the facts. We did have a trial on this matter. The people would be requesting that the defendant be sentenced at the high end of the guidelines, or if the court would be inclined to even consider above the guidelines. And the reasons being is for the fact that I'm going to outline some of the highlights. Defendant was on probation at the time of the offense. She was the driver of the vehicle. She initially fled. She locked the doors, refused to come out, despite repeated requests from law enforcement. She swallowed methamphetamine, approximately 9 grams. According to her statements, drugs and drug paraphernalia were found throughout the vehicle. And by the statements made on the recorded jail calls, she intended to drive to Saginaw to get a lot more. So there's a number of different reasons that the people believe that there would be support. And we do ask that the court sentence the defendant to the high end of the guidelines and to consider possibly exceeding those guidelines.
Sentence delivered, watch the faces. The prosecutor looks firm, but defense seems deflated. Was this outcome predictable, or did it surprise you? Sentencing isn't just law, it's storytelling plus persuasion. Did the judge prioritize law, emotion, or politics here? If you were writing this verdict headline, what would it say? Share your version in the comments.
Thank you. Scott, I know what Ms. Anderson said, but I'm still going to turn to you because you are the one who has the right to make a statement if you choose to do so. Again, if you choose to follow Ms. Anderson's advice, I'm not going to hold it against you because I understand why she's giving the advice. Do you choose to make any statement at this time? All right, thank you very much. All right, well, this has got a long storied past here in this court based upon initially having a plea taken at the district court and then allowing the defendant to withdraw the plea. In fact, I don't need to go back any further, but I'll say, I think even just the findings of the jury satisfy that the court demonstrates that the court was correct in its previous decision. All right, well, now let's talk about this particular case and the facts. Well, when I look at the defendant's prior criminal history, I'll talk about the facts of the case in just a moment, but the facts I'm going to talk about now are her prior criminal history. She is 32 years of age. She is no longer a child, and she has the ability to recognize the wrongfulness of her actions. And she's been in and out of trouble now since she was a juvenile. That all the way goes back to 2006. He started right off by being involved in larcenies.
After sentencing, listen to Kendra's reaction. It's subtle. No tears, no outburst. Sometimes silence says more than words. Is that strength or shock? Would you react the same way in her place? And here's the big one. Does her calm make her look guilty, innocent, or just resigned? Share your honest gut feeling about this moment.
Placed into detention a couple times while on probation. Now that offense allegedly occurred back in November of 2006. And there wasn't a resolution on that case until January of 2007. That's important because she was then placed on. Looks like, and I was curious about this. I don't know if counts 1 and 2 should be switched. You'll see how one has an offense date of November 06 and the other one has April. I think those probably need to be switched. Now, that's important because it tells me that the defendant was discharged from juvenile probation on September 13th, and then she made it about 6 weeks before, just almost 2 months before she got picked up on her second set. So that wasn't very good. And then the November '06 case was resolved on January 26 of 2007. She was placed on a period of probation, and she made it 3 months before she committed yet another offense. And so far, those first 3 offenses are all at least started off with larcenies. 2 of them resulted in larceny convictions. Then as an adult, her first entry is in 2011, a little less than 3 years after her last juvenile case. But that one was dismissed, so I can't and do not consider that. So now she makes it up until February of 2013. And sure enough, she was placed on probation, but it was revoked because she was unsuccessful and violated her probationary terms. Then she made it about a year before she picked up another charge, which, by the way, was her second back-to-back drinking and driving case. Then she made it about 3.
I believe that was the DWLS.
Oh, wait, I'm sorry. Thank you very much. But she was, and thank you for highlighting it. And so I'll take that back. It wasn't a drinking and driving case, but we had an issue here where the defendant tells me right here, even though she's told she can't drive, here's what the state authority is. She's going to disregard authority. Then she made it about 3 years, picked up a shoplifting case. So she's back to crimes of dishonesty. And this one was in another state.
The defense whispers to Kendra, likely explaining appeal options. Appeals aren't easy. They need strong grounds. Did today's objection set up an appeal? Maybe. But appeals take months, sometimes years. If you were Kendra, would you fight? Or accept the sentence? Imagine living with uncertainty that long. What would you choose? Drop your answer below.
Then that case resulted on February 15th of 2018. And she made it about 6 months before picking up yet another crime of dishonesty, another theft case. Oh, and it was also in the same state, which wasn't Michigan, South Carolina. Then she made it a couple years, but the next case was dismissed. And then she picks up the failure to return property in 2013. And she has to be discharged, or doesn't have to be, but she is discharged from probation. Because she failed to comply with her probation. She violated her probation several different times. I'll note that she had looked like intimidating behavior of a person, using controlled substances while on probation, including cocaine, marijuana. So the defendant is demonstrating her inability to be supervised well. Well, then she picks up a couple of other cases that get dismissed, so we'll skip those. Looks like she got some deals and 3 of them were dismissed. Then she picks up in 2023. While on bond, she picks up yet more crimes of dishonesty because now she's back to retail frauds. And so she is definitely a thief. Then she picked up 2 cases actually while on bond. And she had more probation violations, and her probation was terminated unsuccessfully again.
Court adjourns, but the story doesn't end. Sentencing is just one chapter. Public opinion writes another. Some will call this justice, others will see failure. That's the complexity of law. No verdict pleases everyone. Where do you stand? After watching this case unfold, was justice served here? Give me your final verdict in the comments.
Then in 2024, up in Grand Traverse County, she picked up the stalking charge, violated probation. Looks like she violated probation within just a handful of months. Looks like about 4 or 5 months. Then she picks up, also at the same time while on probation, another retail fraud. So again, she's a dishonest thief. And then she picked up while on probation the charges here. And it is quite clear from this case the defendant was up to no good. She said, according to this case, they were on their way to go get more drugs. And so here was a gaggle of 4 people, if I recall, in a vehicle. We know that she was on her way to go get drugs because that's what the evidence showed. Plus, she had nearly $2,700 in cash. and there was $2,700, not hers, but this was on the coat of one of the other people, which helped support that's what they were on their way to go do. But also scales, multiple baggies, and so forth. Then we look at the jail calls. She talks in the midst about taking the 9 grams or swallowing the drugs. She also talks to somebody about, quote, bro, you need to get into that safe. The safe's in his bedroom. There's 2 of them. It's so big the aunties can't carry them, but you can. That's where you need to go.
We're deep into post-sentencing discussion. Notice how the legal team carefully avoids direct answers when reporters push for comments. That's strategy. Anything said now can impact appeals. Silence isn't weakness, it's protection. If you were in their shoes, would you speak up for clarity or stay quiet to play safe? Drop your strategy in the comments.
It is absolutely clear to this court that Ms. Scott has a tendency of lying, that she is a thief, that she was possessing drugs and on her way to continuing, or at least going to be, a drug dealer. This court has zero empathy for her actions. She was found guilty of the right charges. I find that the evidence definitely supports the convictions here. She admitted to the tampering. She's on video for the flee and elude. She's on video for resisting the police officers. And when I watched that video, I thought to myself, well, that's a perfect example of why officers have a difficult job. She gets out, she runs around the car like a chicken without her head, jumps back in the car. Everyone in the car is being yelled at. Everyone in the car is lucky they didn't get shot or tased, all because of the actions of Miss Scott. Now, while they weren't placing people in danger, and I made what I think is the appropriate ruling based upon the facts and the standards of proof, Miss Scott, no, you need to go to prison, and you're going to. The question is do I exceed the guidelines and find that they're inadequate? I'm going to say that I don't find that they're inadequate. Now, guidelines are not mandatory. Can I exceed them? Certainly. But at the same time, I don't find that they're inadequate because I think they were scored, at least as we've narrowed it down, correctly. So the court sentences the defendant to 5 state minimum charges of $68, a crime victims' rights fund fee of $130, a $300 court cost, a $300 fine, $300 attorney fee. I'm going to say that there is a $1,000 fine, and that collection can begin while you're in jail in the term and condition of your probation or parole. Some judges won't post fines and costs and so forth when someone's going to prison, but I don't think there's anything wrong with it. They can be collected as part of your terms and conditions of parole. Now, as to the guidelines and as to the confinement period,
Media spin begins. Headlines flash, cameras roll, and narratives form before the dust settles. Public opinion can be harsher than the judge's ruling. How much do you think media coverage shapes justice? Just reporting or influencing? If you could control the headline, what's the one line you'd write about this case? Share your version below.
This court finds that the sentence it's about to announce is reasonable, proportional, based upon the facts that are contained in the pre-sentence investigation report, the facts that I've discussed, the defendant's prior criminal history, but not so much the criminal history, the fact that she commits crime while on bond repetitively, she violates probation repetitively, she chooses to disregard authority by driving vehicles knowing she's not lawfully allowed to drive a vehicle. And based upon the facts here and how the police were able to find her because they tracked a stolen vehicle. I don't sentence her for stealing the vehicle, but I do consider that based upon, as I've discussed already, the preponderance of the evidence. As to count 1, exercising the right to this court's discretion, not right, but this court's discretion. I sentence the defendant as to a second habitual offender as to all counts, and for count 1, the court sentences the defendant to a period of 28 to 180 months. As to count 2, the court sentences the defendant, keeping in mind the 2/3 rule. The court sentences the defendant while the guidelines say up to 28 months. We know that the 2/3 rule puts it at 24. So the court sentences her to 24 to 36 months. As to count 3, the defendant is sentenced to the maximum of the guideline range, again recognizing that they are not mandatory, but the court sentenced the defendant to 28 to 72 months. As for count 4, the court sentences the defendant to a period of 28 to 90 months, which is the maximum under the guidelines, which again are not mandatory. And as to count 5, the defendant is sentenced to 28 to 180 months. While the defendant has the right to, I think, to petition for boot camp, this moment in time, I would not expect it. The court believes that you were up to no good. You were on your way to becoming a drug dealer and you didn't care and you had a gaggle of people doing it with you. Yeah, no. I don't anticipate me approving it. Maybe I'll change my mind. You can go and request it. Oh, I'm sorry, 275 days of credit for each one of those offenses. And I will allow this to run concurrent, all of them together. And it's taking that into consideration and exercising that discretion that also plays in my mind as to where I stand on boot camp. Ms. Scott?
Family reactions tell another story. Some look devastated, others numb. This isn't just a legal fight, it's an emotional war. Courts decide sentences, but families live with consequences. Do you think justice systems consider emotional fallout enough, or is that outside their responsibility? I'm curious. Should law weigh human pain more heavily or stay purely procedural?
Welcome to the world of drug dealing. All right, this court is going to provide to Ms. Anderson, to provide to Ms. Scott 2 copies of one document. You will place your initials in one copy, acknowledging receipt of the other. This document tells you that you have the right to appeal the convictions and sentences in your case. And because you were found guilty by a jury trial, you have the right to file a claim of right to appeal. Now, if you choose to file a claim of right to appeal and you want, the courts will appoint an attorney to assist you. You complete the bottom half of the copy that you return to the court within 42 days. Again, place your initials on the first copy, neither elects nor waives any right. So if you wish to file an appeal and you want the court to appoint an attorney, you must complete the other copy and return to the court within 42 days, which of course, if you choose to file it now, which is normally what most people do, you may. Anything else, Ms. Odell?
Your Honor, just wanted to clarify, state fees times 5.
Yep.
Times 1.
Yeah, they were all one case file, right? Yes, correct. Thank you. Mr. Denham?
Nothing further.
All right. Ms. Anderson, any further on behalf of the defense?
No, thank you, Your Honor, other than she is completing this.
No problem. I understand and I anticipate that. And based upon what you had already said earlier, so no issues. All right. Thank you very much. We are adjourned.